Parliament is set to forge ahead with its impeachment process against suspended Public Protector Advocate Busisiwe Mkhwebane. The Section 194 inquiry is faced with the historic task of handling the matters relating to the possible impeachment of a head of a Chapter 9 institution. The office Mkhwebane's office, that is, recently pulled out of a request to have the process of removing her halted. So let's get you a sense of where Parliament is at as we count down to this moment. Bring in the committee chair, Mr. Qubudile Dyantyi, who joins us via our video link this morning. Sir, it's great to have you on the program. Thank you so much for making time. Not to overemphasize this, but in some respects, history is being made this week with Parliament set to sit down for this inquiry. Are you feeling the pressure?
There's always going to be pressure, but good morning, Ayanda, Michelle, and your viewers of 4-5. There's always going to be that pressure, but we're ready because in February we would have produced a 6 months kind of plan that ends at the end of September. And so today is the next milestone in that roadmap. And today's milestone is marking the start of the actual hearings into the fitness to hold office of Advocate Busisiwe Mkhwebane. We have all systems go. We would have prepared Friday, and yesterday I was in Parliament to just check even that the bare logistics are in place so that nothing stops us from starting this pioneering ground. We would have established new rules. There would have been legal challenges on the way. There would have been COVID. So it's been in the 2 years in the making with all sorts of off-ramps and potholes that we had to deal with in the way, but we're ready.
Sure. At some stage, people were actually worried about whether or not this day would ever come because of the things you've outlined. What is interesting, though, is the powers that you're given as a chairperson of this committee. My understanding is that I think it's Section 14 of the Powers and Privileges Act enables you to actually give out summons to have people appear before the inquiry. In fact, the Act is the Powers, Privileges, Immunities of Parliament and Provincial Legislatures Act. Anyway, I'm citing that because I wonder whether you feel you'll ever need to evoke those powers. Are you at all suspecting that there may be people who are resistant to appear?
Yes, I understand, and that long title you've just read is done also in conjunction with Section 56 of the Constitution. But as a chairperson of a committee, I do summons in concurrence with the Speaker, and we had already established that. So I have, therefore, those powers delegated to myself. We only use them when a witness cannot voluntarily, by himself or herself, come in front of the committee and produce documents and give us evidence. And we're hoping that all of them will do that voluntarily, but I can share with you, without mentioning a name, that I've already invoked those powers. There will be a witness that will come in front of the committee that have been summoned already.
Sure. You spoke about hearings beginning today. Are you able to get us a sense of which of the witnesses are likely to take to the stand today?
So today and tomorrow, so basically today is kind of scene setting. It's having the evidence leaders that we work with outlining the entire lay of the land about who these witnesses, the nature of these witnesses, what their approach is going to be in terms of getting into this evidence. Because remember, what we have up until today is what we call prima facie evidence from the panel, basically saying there are reasons for you to investigate. The investigation is starting with us. So they'll be doing the opening statements, and you'll expect the legal reps of the public protector to also do the same and make those kind of remarks. Tomorrow, we start with what we call expert witness. A witness, and his name is Hassan Ibrahim, who's going to take the members, the entire country, and explain the nature of this office. It's important. That is the Public Protector South Africa office. Its role in building constitutional democracy, and our role as Parliament into that, so that everybody else we start before the next witness, knowing what we're dealing with. And so by end of tomorrow, because this is what we're going to do, every day we're going to announce the witness that will come the next day. So every witness is unveiled the day before. So the next 2 days is really about setting that scene. From Wednesday, look forward to get the first witness.
South Africans will be forgiven if they feel like they're going through a moment of deja vu with the state capture inquiry, even though, to emphasize, these are completely separate things, of course. I do wonder, though, whether, Mr. Dyantyi, it's a far-gone conclusion that the suspended public protector will participate and cooperate with this inquiry, because we know her sentiments about this, especially if, her previous court actions are anything to go by.
Our approach, which guides us, is fairness and rationality. We've applied that. We have been very patient. She exercised her rights almost in every step of our process. Going to court, we respected that. But all of those doors are now behind us. She is going to be with us physically today in Parliament, together with her legal representative. Because remember, we're starting this with a two-pronged outcomes. We are seeking evidence and facts that will exonerate her. At the same time, also evidence and facts that are going to help us make adverse findings on her and therefore start removal processes. So we get into this open-minded, into this space.
Interesting, that approach, because the questions that still loom around this process is what the criteria ultimately will be in determining whether someone like Busisiwe Mkhwebane is fit to remain in office. Because that concept, especially for people who aren't working closely with these issues, may feel quite elusive.
Yeah, you're breaking up a bit, but I got you. The test for this fitness to hold office, there are two areas of concern that have been raised by the motion. We're testing her competence and to be in that office, as well as whether she has misconducted herself. Those are the two grounds that we'll be focusing on. So every evidence and that is going to be in front of us has got to speak to those issues, either helping us to exonerate her or also helping us to make findings and therefore come back to Parliament and say, these are the reasons, these are the findings, and therefore we think that she has to be removed in office.
Of course, I'd appreciate if perhaps you're not able to directly answer this question, but doesn't mean I'm not going to try my luck. The president has in many instances come up as a party of interest. I can see you already smiling. In a lot of things involving the public protector, as well as issues related to this particular inquiry. As the person who's leading this inquiry, do you reckon the president has something to answer to here?
Look, the inquiry that we're driving triggers the involvement of the president at some point. And in terms of Section 194 of the Constitution, it triggers the involvement of the president at least 2 times. That at the start of the process, which we have started in February, Section 194 3A says the president may suspend that head of the institution. In other words, it's his discretion when he does that. But at the end, when we have findings and the National Assembly decides that she must be removed, the president, and here it is very emphatic, that he must act on that recommendation and remove the public protector. On the issues involving the president and public protector, we've always been unfazed and focused on our work in saying that what pertains to the president and public protector is their issue. Our work is not affected by that or not diverted, including, Ayanda, the fact that the Office of the Public Protector itself has withdrawn certain documentation. That is not going to affect our work. They must deal with that as an institution. We're marching on because the work of Parliament is clearly demarcated in terms of what it needs to do. We see everything else that is happening, but we're staying focused in our lane.
All right. Well, it's good to hear, especially because there's so much at stake, not least the precedent that you're going to be setting once this process finally gets underway. For now, thanks very much indeed for speaking to us. Qubudile Dyantyi is the committee chair of the Section 194 committee that's going to be looking from today into Busisiwe Mkhwebane's fitness to hold office. An unprecedented inquiry for Parliament, at least in our democratic history.